Good morning, everybody, and welcome to the Texas Public Policy Foundation. My name is Derek Cohen. I'm the Director for Center of Effective Justice here at the Texas Public Policy Foundation and of our Right on Crime campaign. I'm really glad you guys were able to join us and partake in some Chick-fil-A. Just quick housekeeping notes that this will be live streamed, and this will also be available for download. Am I correct, Clint? Later on once we get it posted. So if there was a really good point that I made and I forgot about it, if you ask me about it afterwards, you can go to the tape replay on that and get that from our website, texaspolicy.com. As soon as we get it uploaded, you can see a link to our YouTube. We have a great program for you today. Another housekeeping note that if you need to use the restroom, just straight out that door right there and to the left. It'll take you right there. Feel free to go at any time. It's going to be a casual conversation up here. And really look forward to talking about this topic with a broad panoply from folks on the right to folks on the left, and great resources that we also have here in this room. So I'm really excited about getting this conversation going. And so what are we talking about today? We're talking about bail. We're talking about pretrial release. The actual topic, the actual title of this primer is Bail Reform, the Balance of Liberty and Public Safety. One of our founding principles upon which this country is based is our presumption of innocence. Serial abuses on behalf of the Crown against the colonists prompted authors of our Constitution to shackle the state when it comes to matters of criminal procedure. Only by meeting the fantastical burden of proving an allegation beyond a reasonable doubt can the state actually visit harm on an individual's life, liberty, or property. However, the finality of that right comes at the conclusion of a criminal trial. Until then, even the factually guilty, who readily pose an identifiable threat to victims and communities, are entitled to presumption and a freedom from government injury. Only in limited cases can magistrates preventatively detain the accused before the pendency of their trial. We certainly cannot have dangerous criminals running amok in our street with law enforcement unable to deal with serial victimizers for months or even years. Nor can we also treat our justice system like a Soviet-style unilateral arbiter of justice before a case is even adjudicated. Well, what are we to do? Enter bail. By posting an amount supposedly equal to the inclination not to fail to appear or not to offend, the accused is seen as having skin in the game. Meaning that if they do not appear or keep their nose clean, the sum of the security is forfeit. Of course, given the informational asymmetry of our criminal justice system, that amount is murky to say the least. This lack of information touch off cascading series of market distortion. If we look at the accused bail amount is set at X, they can commercially finance the release for only 10% of the set amount. Much like its financial equivalent in securities trading, buying on margin, this produces endogenous and exogenous complications within that actual system. Elected judges, cognizant of public safety concerns, start feeling the pressure to set bail at higher amounts than prudent to ensure a perceived high-risk offender is unable to purchase their freedom to escape and then reoffend. This rising tide truly does raise all boats, just not in the manner that we prefer that it do. Much like rampant inflation in college tuition, high-risk defendants distort the amount for lower-risk defendants. As a result, Texas jail population has increased from 32% of pretrial detainees to 75% pretrial detainees, and this is just in 25 years' time. And this is against the philosophies articulated in the controlling cases on pretrial confinement or pretrial release, as articulated by Rehnquist and Jackson. And so I have this slide here I'd like you to see. This slide is the increase in basically the disposition and the percentage of pretrial. And so as you see, we have a pretty steady increase both in percentage and in count. And we see this across the country as well. So in some jurisdictions, like Toledo, Ohio, where I'm from, if the accent hasn't given it away already, actually reformed their system to great success. After the implementation of a risk assessment and enforcement policy, the failures to appear dropped by a factor of 30%, while offenses and violent offenses have been slashed in half. I want to pivot back to this slide. This is what it looked like before. The blue slice here is a successful issuance of pretrial conditions, meaning that the person showed up and the person basically fulfilled the terms of that release. This was in 2015. In 2016, they put in a risk assessment enforcement policy. Look at that blue slice there. That is a smashing success when it comes to what we can do in the terms of criminal justice policy. However, not every jurisdiction has had this rampant success. We'll take a look at what happened in California. The state of California, as is their wont, completely overreacted and actually prohibited the detention of most misdemeanors regardless of criminal history or risk. So we're actually prohibiting folks that might be a risk to our communities from actually being assessed. So what's the solution to this problem? Well, we have two irreducibly and interrelated complex issues, and that's what we're here to discuss today. I'd like to start off by introducing our panelists. First, I have David Slayton. He is the Administrative Director of the Texas Office of Court Administration, the body that oversees much of the judiciary and functions as their administrative entity. And also Trisha Trigilio from the American Civil Liberties Union of Texas. And Trisha, not only being a policy expert on this particular issue, is also participates in the litigation on this as well. So I'm really looking forward to some of our discussion today. I'm going to kick it off with David Slayton, because I think one of the foundational components to the bail systems that have been proposed or that have been rolled out in other states is this idea of a risk assessment. So what I'd like to have now is for David to come up here, explain to us what a risk assessment is, and essentially how does it work. We've heard these ideas that it's this black box that is throwing people in jail. We've also heard that it's basically a spreadsheet that turns a whole bunch of people out. And like most things, I'm sure the truth is somewhere in between. So without any further ado, David.
Thanks very much, Derek. Good afternoon, or maybe still good morning, everyone. As he said, my name is David Slayton. I'm the Administrative Director of the Office of Court Administration. I also serve as the Executive Director of the Texas Judicial Council, which is the policy-making body for the judicial branch. One of the things before we get started, I hope maybe some of you grabbed a handout as you came in, but if you did, take a look at this page. It has a whole bunch of writing on it. Has a seal of the state of Texas at the top, and it says County of Smith. I'm going to give you all about 15 to 30 seconds to read this real fast, and I have a question for you. So your timer starts now. Okay, your time's up. That was 30 seconds. I gave you an extra little bit of time there. So I need someone to be a very brave volunteer for me and tell me, this is a real case, what would you do with regard to setting bail for this individual? Someone please raise your hand and be my brave volunteer. Anyone?
Over here.
All right, what would you do?
Well, first you have to assess whether the person is a danger to the community and whether he has ties to the community.
This is all you have. So this is all you have. Tell me what you're going to do with just this information. What would be your decision?
I would need more information that if that's all I had and I had to set bail, it would depend on the charge. Actually. If it's a serious violent felony or if it's criminal misdemeanor, of course it would be different. So what the actual numbers are is just a judgment call.
All right, so I know some of you who may be watching the broadcast may not have heard all of that, but basically the gentleman explained that he does not have enough information with which to make a intelligent decision with regard to bail, and would certainly need more information with regard to the risk of the defendant and other types of information. What I'll tell you is that we have talked to, we've researched every county in the state, all 254 counties. We know what their magistrates have whenever they are setting bail. And in all but about 25 counties in the state, remember there's 254, all but 25, this is the information that a judge has at most. Sometimes they don't even have this. So judges are using this type of information, generally spending about 15 to 30 seconds with each defendant, and they're setting bail based upon that information. That is a fact. It's what's happening in most every county in the state. We talked to the judges about this issue because we were concerned about that. And we said, well, how then do you go about setting bail in these type of cases? And 80% of the judges who responded to the survey, these are magistrates doing this every day, 80% responded that they, quote, use their gut feeling to set bail, and that they do not believe their decisions are contributing to public safety. Yeah, question.
Are these 25 counties rural counties?
The 25 counties who have so that's whatever that number would be. The 25 counties who have more information than, most counties have this. The counties that have more information on the defendant are, it's a mix of urban and rural, mostly urban counties or middle-sized counties and above. And so what the judges have responded back to us in mass is that what they are needing most of all is more information about the risk of the defendant. And so enter what we call the pretrial risk assessment information system. The short term is PRAISE Texas. So if we can get this flipped over, I want to show you what we have done. So OCA really decided one of the things that would be most helpful to the judges and what they were asking for was a validated pretrial risk assessment that would provide them information that they would be able to use as part of their decision-making process. That would reveal to them two things: the risk of flight and the risk of danger to the community from reoffense. And so we started looking at how could we do this, and there are a couple of ways to do this. One would be that we would adopt a risk assessment which would require every single defendant that's arrested to be interviewed by a person at the county. If you know most of our Texas counties, they are not staffed to do that. And so we felt really quickly that that would not be an option that would be a worthy one that we could actually be successful with. And so instead, we moved to looking at are there any non-interview based risk assessments which have been shown to be validated and predictive? And there are a couple of them. We ultimately chose one which is something that's been in the news because Harris County is now using it. It is the Arnold Foundation's Public Safety Assessment. And so what you're about to see is we've taken the public safety assessment, we've put it into what we refer to as PRAISE Texas, and the intent here is to use that information to provide information to judges. You also have a handout in your materials. If you didn't grab one, you can grab one as you go out, which shows the factors which make up the pretrial risk assessment system, and you're going to see them as we go throughout this demo today. So this is literally live. I'm just on the website, so anybody who had login credentials to this could access the system. I've already logged in. I will tell you that when you see this, you're going to see that I'm a user who's set up as if I'm in Smith County, Texas. And so we're going to use the information here to begin to calculate a risk assessment. So basically what this is a individual in a county could basically add a record. So we're going to do this here. I'm going to use a particular case, the probable cause affidavit you had here. I'm going to show you what this looks like. So the individual's name that we're going to use is DeBrett Black. There, as you can see on here, there are certain things which are required fields. You see the asterisks on here, and then certain things which are not required. So I'm going to enter just the required fields today. A county could obviously collect more information if they wanted to. This individual's date of birth is January 28th, 1985. I could probably do this a lot faster by just typing it in, but just so you can see. So you can enter his address information if you want, all of that. We can also put in the date of the arrest, and for this purposes, I'm going to enter 3/27/2015. I guess I should actually enter that correctly. And that's the date of the offense. I can enter the court. We have this set up where it only pulls up courts in that county. As I mentioned to you earlier, I'm showing up as if I'm in Smith County, so these are the courts that would pull up, but once again, not a required field that they don't have to. We can also enter the state identification number just for tracking purposes and other types of information. The next thing that we do is we can put in the defendant's offenses. In this example, and you'll see it pulls up the examples, this defendant is charged with three things. Once again, pulling straight from the probable cause affidavit, you can actually see on the bottom, it actually says what these three offenses are. So the first one is aggravated assault of a public servant. The second offense is reckless driving. And the third offense in this instance is evading arrest. with a vehicle. Here we go. So I've added the 3 offenses for which this defendant is charged. This is where the risk factors begin. So there are basically 7 questions which run the risk factors, and as I mentioned, they're straight out of that assessment. So the first thing is asking is whether or not the defendant had a pending charge at the time of the offense, and in this case, the defendant did not have a pending offense at the time of the arrest. The next question is whether or not the defendant has had a previous failure to appear in the previous 2 years. So I will tell you for purposes of this demonstration, I don't know the answer to this, and I'll talk to you about this at the end of the demo about information that we believe we'll have to use this. But for purposes of this, let's say that the defendant has not had any prior failures to appear. Same thing on the, so one's within the last 2 years, and then the other is older than 2 years. You can see we can select the number of failures to appear if there were multiple, but for this purpose, we'll say no. The next question is whether or not the defendant has had a previous misdemeanor conviction. I can tell you from pulling this defendant's criminal history information from the public DPS website, which I chose not to give you because I wasn't sure that was a crime or not. For purposes of this, I can tell you that he did have previous misdemeanor convictions. And with regard to previous felony convictions, he also had a previous felony conviction. With regard to the number of violent offenses, he had 1 previous violent offense conviction, so I'm going to say 1 to 2. You can see that there's different amounts here as well. And then with regard to his previous sentence to 14 or more days in jail, the answer is yes, he did. So a couple of things I want to point out to you that can be done here. One, a county could, someone interested in a county could save this information, come back to it later, or they can hit submit. If they hit submit, it goes to a list, basically a queue that is waiting for the judge. You can see over on the status side, these are the list of cases that are waiting for a judge to review them. So just for purposes, I'm going to pull up now what is the pretrial risk assessment that has been calculated with the information I just entered. Nothing more has been put into this for this gentleman named Brett Black. So you can see that basically his failure to appear score, remember I told you I didn't have all of his failure to appear information, but with the information I put in, his failure to appear score is 2 out of 6. It's showing green in here. His new criminal activity risk score is 4 out of 6. You see we've shaded this yellow here on the paper you have. I actually shaded it red. It sort of would depend on the cutoff with that. And then the last one on new violent criminal activity risk flag, the answer is yes. So this defendant has a low risk of failure to appear, a moderate to high risk of new criminal activity, and a high risk of new violent criminal activity. So pausing here, I'm going to go back to my brave volunteer. Now, knowing this information, what would you want to do with this defendant?
Has he appeared before the judge, or are we going just by the paper?
You're going by, he's standing before you right now, but let's just say you're going by the paper for the purposes of today's demo since he's not here.
You asked me what bond I would.
What would you do?
I would spend at least a few minutes talking to the defendant and verifying some of this information.
Okay.
Getting a feel for whether he respected the court's process enough to show up. And of course, I would put a lot of emphasis on whether the crime was violent. As you know, David, for bail purposes, you presume that the person is guilty. You don't have a presumption of innocence when you appear before bail. You presume guilty. Assuming you're guilty of the offense, it would be risky to let him out into the community.
Right.
Some of that you gotta get a feel for, not just on paper, but by talking to the defendant. To verify employment and time.
I know you didn't have very long to read this, but let me just tell you what happened in this case that you have before you. If you had a little more time, you would figure out that this defendant started running from the law enforcement officers, and at a speed of 105 miles per hour, turned his car and rammed another trooper's car, and so that's where the aggravated assault of a public servant came from.
But those facts aren't
It's in the probable cause affidavit. You could have read it, given a few more seconds, and then with this information and that, what would you want to do?
Well, again, I would presume that he's guilty of the offense.
Okay.
And I would think if I let him out on a very small amount of bail and he injures someone, people are going to be asking me, what were you thinking?
Right.
So I would tend to set bail at least 25 to 50,000.
Okay.
In a case where
All right.
potential violence is part of the scenario.
Okay, so this gentleman says he would set it somewhere near $25,000 based upon the risk. I know that some people might. How many of you in this room would say he should not get out? Anybody think that he should not get out? Okay, so there's a few hands in the room going up. How many think that $50,000 is the right amount? Okay, so some of you are just saying, I'll just listen to see what the answer is to this. So I'll tell you what happened in this case. The judge, once again, remember, had this information here, probable cause affidavit. The judge set a $15,000 500 bail, $10,000 for the aggravated assault of a public servant, $5,000 for the evading arrest, and $500 for reckless driving. And as you probably know in Texas, with commercial surety bondsmen, this defendant only had to make 10% of that amount, as Derek pointed out, to bond out. So he bonded out with $1,550 and was on commercial bail. This is the gentleman who, about 3 months later, when pulled over by Officer Trooper Damon Allen, got out of the vehicle and shot and killed Damon Allen. Now, let me tell you what the situation was that the judge did not have access to information, which we would have access to through the pretrial risk assessment. The defendant, a couple of years before this offense for which he was arrested, for which the judge was setting bail and set it at $15,500, had previously interacted with a sheriff's deputy from Smith County. And whenever the sheriff's deputy came up to him and started asking him questions, he attacked him and beat him to a pulp. There's video of this from the trooper camera in the vehicle. Beat him up. Then he comes and he rams a trooper vehicle going 105 miles an hour. And then of course we know the very unfortunate incident where he shot and killed the DPS trooper. At the bottom line, the judge did not have any of that other information that I just told you. And unfortunately, that is the situation that most of our judges find themselves in today. The reason why we think this pretrial risk assessment is so important is because it does give judges information, allows them to ask further questions. What are these violent offenses? Can I see his criminal history to see what else happened? Have that information so that they can be saying that. What we know is happening in many counties, judges have told us this, is they're using a schedule based upon the offense. If it's evading arrest, it's $5,000. Doesn't matter if you have all kinds of issues in the past or not. The other thing you should be aware of, and I hope we'll talk about this later today, is that in Texas right now, there is virtually no way for a judge to make sure someone stays in jail. They cannot detain them without bond. So everyone can get out. I use this example because it's the biggest example I could think of, but I've told folks if Osama bin Laden would have been arrested in a Texas county before 9/11 or even after 9/11 and charged with an offense, there would have been no way for a Texas judge to keep him in jail. Think of the most risky person that you can think of. That is the situation we find ourselves in today. If someone has money, they will get out. If they don't have money, they won't get out in many instances. And a lot of the times the issue is that judges just don't have the information with which to set it. So they're relying many times on a schedule or their gut feeling with which to set it. So this is the risk assessment. I'm happy to talk about it a little bit more, but for purposes of moving along here, I'll turn it back over to Derek.
Well, thank you so much, David. And before we bring up Trisha, I do want to point out that David illustrated something that's really key in this whole discussion, is that we do have a constitutional guarantee that outside of capital murder that you will be released or given a number to meet to be released. And that's what I was talking about when I was referring to the informational asymmetries. As David demonstrated, a lot of times that information is not in front of the magistrate at that particular time, and they basically just have to use their particular gut sense to go ahead and assess that. Now, that's what actually can be seen as, perhaps in conflict with legal tradition or certain, just general tropes of our legal system. And that's what our next guest is here to talk about. That's why I'd like to call up Trisha Trigilio and from the ACLU of Texas, who has a different perspective on that, and a perspective that I think will really be good for kicking off this robust discussion that we're going to have in our moderated discussion coming up after this. So, Trisha?
Thank you so much, Derek, and thank you for inviting us to be part of this panel. Good afternoon, everyone. I wanted to open briefly this morning by talking about what the ACLU's organizational goals are in the bail reform space, and then talking a little bit about how we can accomplish those goals. So what the litigation can and can't accomplish, what we view as necessary legislative solutions for meaningful bail reform, and then what some of the limitations are that we see with risk assessment tools. So first, what are the ACLU's goals? I think the ACLU's goals are probably shared by everyone in this room. Our goals in the bail reform space are to fight racism in the criminal legal system and also to reduce pretrial incarceration. So what can the lawsuits accomplish and where are they really kind of fall short, even if we're completely successful? There's already a Supreme Court precedent that's been on the books for a long time, as we've discussed this morning, that touches on what the standards are for pretrial detention. The question that these lawsuits are addressing, both in Texas and across the country, is whether or not bail systems, as they've developed over the last few decades, can actually live up to those precedents. There are injunctions in place in major cities around the country, including San Francisco and New Orleans, holding that their bail systems fall short. And the same is true here in Texas. There are lawsuits pending in 3 different jurisdictions: Harris County, Galveston County, and Dallas County. The Harris County lawsuit has already gone up to the Fifth Circuit and generated appellate precedent that's binding on courts statewide, and the Dallas and Galveston cases are really on their way there. This is a kind of a summary of what the lawsuits are either seeking or what they've accomplished thus far. There are 2 major things that I want to note here. First is that the Harris County case went up and generated binding precedent that courts have to make an ability to pay inquiry and findings concerning the reasons that bail would be set in an unaffordable amount within 48 hours of arrest. And SB 628, which is the major bail reform bill that's on file now, wouldn't enforce that precedent. It would allow that hearing to be delayed by up to 10 days. The other point I want to point out is that there's kind of new issues on the horizon that go beyond what this Fifth Circuit precedent has already generated. The first one I emphasize is that the lawsuits are seeking a higher standard for the findings that need to be articulated on the record. Right now, judges just need to state reasons why bail is being set in an unaffordable amount. The lawsuits are pushing that a little bit further, saying the reasons on the record need to be held to a specific standard. More specifically, there needs to be a finding that jail is necessary to achieve the government's interest. So pretrial detention is the only way to reasonably protect public safety or secure appearance in court. The finding also needs to be by a higher evidentiary standard, which is the clear and convincing evidence standard. Those are both findings that are required under SB 628, but again, they're required in a hearing that can be delayed up to 10 days or more. So before I move on to legislative solutions, I just want to point out these are 3 counties that have been sued. These lawsuits require an extraordinary amount of work. The ACLU of Texas is not interested in filing 251 more lawsuits to make sure bail reform visits every county in Texas. I personally am definitely not interested in doing that. And even if we accomplished all of the goals and the relief that we're seeking that you see listed on this slide, we would have an incomplete job, in our opinion. We wouldn't really achieve meaningful bail reform in Texas. So we think legislative solutions are really necessary for reform in this space. These are some of the legislative fixes that we think will be essential to have a meaningful, modern pretrial release system in Texas. I won't walk through all of them. I'm sure they'll come up through the discussion on the panel, but there are 2 specific things I want to flag. One is the importance of a statewide reminder system to mitigate the risk of failure to appear across the board. Research shows that the vast majority of failures to appear are not willful. People have competing obligations, competing considerations. They need to be reminded of when their court date is. They need information about the logistics of getting there. And they also need to be warned about the consequences of what will happen if they don't show up. There are really cost-effective ways to do this that lower the risk of failure to appear for everyone. One that's really popular and has been very successful is a text message reminder system. So if the court implements a system that sends people text messages that say, here's the date of your court location, do you need any additional information? They've seen appearance rates shoot up, and the most common reply that they get back to the text messages is something like, yes, I'll be there, or thank you. So these are really cost-effective ways to mitigate risk and lower rates of detention. The other thing I wanted to point out is, if you look at everything we're looking at under fair hearings, counseled hearings, hearings that are individualized, and rigorous findings justifying detention, along with an automatic review for anyone who's automatically detained, an automatic review for anyone who is ordered detained. That's, again, something that SB 628 requires. So we're really seeing the proposed legislation move in the right direction toward what would look like really meaningful reform. Again, the only problem here is that that hearing's not going to be prompt, and it can be delayed for 10 days or more. Finally, I wanted to wrap up just by flagging some issues with relying on risk assessments as the primary or sort of the only tool for making decisions about pretrial release. Risk assessments can be extremely useful, as was just demonstrated, but they're not necessary to any system of pretrial release, and they're also certainly not a panacea. SB 628, together with the tool that was just demonstrated, both address many of the concerns on this slide, but definitely not all of them. One major concern that we have is transparency. The legislation that's proposed would require that magistrates across the state look at the outcomes of this risk assessment tool to make decisions about release, as we were just doing in the hypothetical exercise. The problem is that criminal defense attorneys and the general public don't have access to the calculation that's used to generate those numbers. So we need that transparency so that defense attorneys can understand where these scores are coming from, where these red flags are coming from, and then make individualized arguments to judges about why they may not apply to their individual clients. There are two more things I want to flag here. One is the importance of validation. These tools need to be validated in local jurisdictions to make sure that the numbers they're spitting out actually make sense in each locality where they're used. Right now, the legislation doesn't require that. The other is that the tools should be used to release people rather than detain them. So this is one of the, I would say, our biggest worry about SB 628, is that the bill requires that everyone go through the risk assessment process and then see a magistrate before they can be released. In our view, there are wide swaths of people who don't need to go through the risk assessment process because we can tell, for example, someone arrested with no criminal history for trespass who's 60 years old is really not someone who in any universe is going to qualify to be detained pre-trial. So we want to leave room for judges to establish standing orders that allow for people to be released without going through the risk assessment process. The other problem is that the risk assessment alone isn't a tool that can be used to detain. It's an actuarial tool, but it's not really individualized information about the defendant. And I think that this exercise was really helpful, particularly because what everyone wants to answer when we're trying to figure out what that amount is that we want to articulate is, can I ask the defendant some questions, right? Can I ask him why he was beating, why he was behaving this way? Observe his demeanor, learn more about what his background looks like, have his attorney give me information about his employment or his family life or his mental health. That's all information that we really need to make a meaningful determination about these people. And looking at a flag that's yellow or red and treating that as a basis for detention isn't going to satisfy the Constitution. When we are having a system where people are going to magistration with just that one piece of paper plus the flag, it's not sufficient to justify detaining someone pre-trial. So those are our biggest concerns about risk assessments in this area.
Thank you, Trisha. All right, I'd like to move into the moderated discussion portion of the program. I would like to highlight that you heard it here first. The ACLU is done suing after these 3 counties, so we're going to hold you and Nick to that. So, but I do think that this did raise some very interesting questions, both about the technical aspect of the risk assessment, but also kind of the general thought on pretrial release, in general. And I want to start off by pushing back a little bit and just kind of getting some clarification on where you said that the low-level folks would basically have standing orders for that. The problem is, though, is that we don't look at necessarily, criminal history. Criminal history is a constituent point of the risk assessment, but the individual nuances of the criminal history are important too. If we don't have some sort of mechanism for which we actually look at the risk of that individual, and I know that in the places that have really rolled out a robust risk assessment system, a non-binding one, but one that is informative to the magistrate, we've seen a lot of basically, some look that not everybody gets that magistration. From the academic standpoint of that, is that you're basically cutting a low risk but still contributory population out of the overall risk pool. And so is there a concern that that might actually skew the findings? For example, if we're only magistrating folks that are not directly assessed, but by proxy medium to high risk people by the dint of their offense, is that not kind of tainting the release numbers in general?
So the concern would be that by allowing these standing orders that would facilitate release for people in certain classes of offenses, that ultimately the statistics would change? I mean,
exactly, because we're basically cutting down the denominator of people that would potentially abscond or reoffend.
Right. Well, so I guess I don't know why changing the statistics themselves would be an inherently bad thing. I mean, a cite and release policy accomplishes the same thing. We definitely don't want to be cutting away officer discretion or judicial discretion in any way that could facilitate release or a less punitive or incarcerative system. We're not looking at a system that has a problem of detaining too few people or prosecuting too few people. It's the opposite. So where we can give officials discretion to say, this is not a case where I need to put handcuffs on someone, or this is not a case where this guy needs to sit here for 16 hours and wait for a judge to say, yes, I'll let you go. I would have signed a standing order that let you go, but state law doesn't allow me to. It's not a situation we want to be putting ourselves in.
David?
I just want to clarify one thing. I think it's important. The introduced version of Senate Bill 628, I'm going to talk to Trisha afterwards, does actually allow a person to be arrested before they go before a magistrate. Right now, it just says that nothing in the law prohibits that. I will tell you there's been some discussion about should that person have a risk assessment before they're released, before seeing a magistrate, and I think there may be some movement on that issue. I think from the Judicial Council's perspective, we think there could be standing orders which would allow people who are low risk, considering all the factors, to be released before they go before a magistrate. Why would we hold them for 24 hours or 48 hours or whatever it may be if we know that they're low risk across the board? If the magistrates have said these classes of offenses for all low risk people, the person can be released on a personal bond or whatever they want to do without having to wait for the magistrate. I don't think there's any issue with that, but I can tell you that the legislation as filed currently doesn't even require the risk assessment. It allows people to be released prior to magistration without even having a risk assessment. And
certainly I think that highlights some of the issue where, especially if you look at some of the legislation that I believe is actually up on Wednesday of next week, there's a bill that's going to be up that's going to prohibit arrests for Class C offenses for which the ultimate punishment, if met out in the most punitive way possible, is but a fine. So this is a no arrest for non-jailable offenses. So things like that make sense, but would we want to actually, and this is an open abstract question, would we want to actually put a blanket out there saying, but for X, Y, and Z, where we might have assaultive or sexual misdemeanors, would we want to have blanket exemptions for magistration for like Class A and B misdemeanors? I think that's the question that this kind of poses.
I mean, I think the issue is right now we already have that. So people can bond out if they have money. They can bond out pursuant to schedules now before they see magistration. What I think the Judicial Council, as we're looking at this, says that's fine, but we ought to have a risk assessment done before they bond out, because what if they're really high risk? Because even felons can do this right now. It's not just misdemeanors. Felons can too. Shouldn't we know if they're high risk? So the example I just gave you, DeBrett Black could have bonded out before he ever saw a magistrate pursuant to a schedule if the judges had a schedule in place and a standing order in place in that jurisdiction. So I think the thought is, well, if they're low risk across the board, why not? Why wouldn't we allow the judges of the local jurisdiction to come up with a standing order that would allow them out on that before they and with no delay? I think our thought is the more that if they're low risk and there's not a reason to keep them in jail and there's not some other reason why they should go before a magistrate, why shouldn't they be allowed to bond out as quickly as possible? That's kind of I think where we're headed with this, is providing that option as well, and that's I think the best course. But I do think it's important that I think we have some concerns, whether it be on the high end or the low end, saying across the board, this is the decision. And so we ought to make sure that it's truly based upon what we're really trying to figure out. What is the risk of this defendant of failure to appear, and what is the risk of this defendant of safety to the community in reoffense. Those are the two things that we're really trying to consider when we're looking at bail. And if you start making class-wide decisions of classes of offenses based upon that, then I think we're sort of undercutting what we're trying to do here.
That's the California model.
I would just want to jump onto that and say I would be even more concerned about a system where we're making class-wide decisions based on whether you have a few $1,000s to pay a bondsman. So if you can bond out before magistration, and we're letting entire classes of people bond out not based on what a risk score is, based on what an offense is, based on what criminal history is, just based on the amount of money they have, I think that's an even more concerning system. So even when we hear the argument about using wealth or allowing wealth to facilitate early release for some people, it doesn't sound like an equitable system to us. First of all, it's not going to fight racism in the system just because of disproportionate lack of wealth among people of color. And more importantly, it's not going to mitigate risk. So if we really think that there is a risk associated with a certain population, we need to make a public policy judgment that either we're going to hold people 24 hours for an adversarial bail hearing or we're not. But it should be the same decision, rich or poor. There shouldn't be a way for people to sort of exempt themselves from a system that others are subject to.
And that brings up another good point that I think kind of gets lost in the translation here, because I think that when it comes to approaching bail reform, I think that we all have public safety in mind. But as I mentioned earlier, it is one of a number of priorities. Like I can speak for folks on the right, myself included, and actually I can speak for Attorney General Ed Meese, because he said so a couple weeks ago. He echoed your point about it should be a tool of release and not a tool of detention. It's just squaring that particular point away with the policy that brings it about.
Can I add one thing to that?
Sure.
I think it's important to know. I mean, I don't know if there's any judges in the room. I'm looking around to see if I recognize any, but I think if you talk to judges, one of the things that's oh yes, I see one just walking in. Hello, Judge. How are you? One of the things that's a challenge, I think, for judges is this issue of a fear, especially when they have a lack of information. The fear of letting someone out who will do something. And so the tendency a lot of times is to increase the bond amount because maybe that'll make me feel better as a judge that maybe someone, if I set a higher amount, then I have a greater likelihood that they won't go commit a new offense. I know that doesn't probably logically make sense, but I think that's where judges are oftentimes. And so I think by having more information, I think judges can then go back and say, listen, with all the information, because right now they have no information to make this, so that's all on them. So any criticism is going to go straight to them. Versus if they have all this information, now they can say, look, I made the educated, with all the information, I made the educated decision based upon all the information I had that pretty much every other judge in the state would have made that same decision or a very similar decision. I think it gives judges the flexibility to feel more comfortable about making decisions of a release, even with the public safety risk, because they have the information to know this person's risk is low. So why shouldn't I let them out on a personal bond?
And you hit on that very same point, that kind of disconnect between money and risk. I mean, the intuitive thing, and well, I think it is intuitive just from studying this as an academic subject, is that you essentially have the link, like, well, if we give them a low bond, they're going to go reoffend, but a high bond, they won't. Well, it's true insofar as if they can't post. And so I want to dig into that just a little bit, and feel free to either of you to take this, but with that disconnect between risk and money, and with the advent of some sort of inquiry into whether or not an individual can pay, don't we run into the problem where if we have somebody that's, let's say, presenting dangerous or presenting high risk, let's say it was maybe green or maybe yellow in the first box and then red in the next two, but that person was slam dunk indigent, like there was no question about their inability to make bond, should that inability to pay then actually factor, should that inoculate the public safety threat? And that's something that I think that when we have these discussions publicly, that people still struggle with.
So I'm really glad you asked that question, because I obviously have a very strong view on it. So the money, whether you have money or don't, is not going to mitigate your whatever risk of dangerousness you would pose to the community for multiple reasons. One is just that studies have shown that secured bond, which is what we're all familiar with when we say bail, prepaying either in cash or paying a bail bondsman, is no more effective than signing a personal bond at securing public safety. So it's equally as effective whether you make someone prepay or sign a promise, yep, if I mess up, I promise I will pay this, I will owe the court this amount of money down the road. So access to cash should never stand in the way of someone's release for that reason. Moreover, when it comes to public safety, separate from court appearance, your bond can't be forfeited if you commit a new crime. The only reason your bond can be forfeited in Texas, you lose the money back to the court, is if you don't appear in court. So no matter what amount of money you're posting, it's never going to mitigate the risk that you're going to commit a new crime, because you don't lose it if you commit a new crime. In fact, if you're rearrested while you're out on bail, your bondsman has a defense to forfeiture of his bond money if he says, oh, she was in a jail cell and that's why she didn't show up at her court appearance. So if you're committing a new crime and you get arrested, your bondsman gets off scot-free with your money. So it doesn't matter whether you're indigent or not. It's not going to affect the public safety risk that you pose if you can't post secured bail before you're released.
I want to add one more thing to that too. Actually, Trisha's being kind, saying that there's really no impact. But we have a study from Texas that we did a couple years ago. Well, actually, Texas A&M did it through their Public Policy Research Institute, comparing people who posted cash money bond and people who were released on personal bond. And what the study shows, I encourage you all to go look at it, dig into it, criticize all you want. I feel very strongly about its factualness. That in jurisdictions where they use money bond, that the defendants are 9 times more likely to commit new violent offenses or new gun offenses. So in fact, the opposite is true. It does not, money bond does not reduce the number of criminal offenses, but people who are getting out are committing more of those type of crimes. So it's definitely not a panacea to try to keep people from committing new crimes. So that's the issue there.
I want to add just a little bit more on top of that. I'm glad we're building on each other here.
This was not planned.
So a little bit of the background for that great point about how at the end of the day, use of secured money bail actually ends up making recidivism rates worse, is that because people can't afford bail, or it might take some time for them to post the bail, or there's just administrative lag between the time that the bail is posted and the person is released, secured bail causes unnecessary pretrial detention. And starting at hour 24 of pretrial detention, we can detect effects of collateral consequences that are bad for public safety. Recidivism rates go up once the person is actually released, and failure to appear rates go up once the person is actually released. The theory here is that the time in jail is destabilizing, and a lot of people in jail, particularly those who can't post their bail quickly, are kind of living on the knife's edge, really. And if they miss work once, they're working the type of job where the boss considers them to be disposable and they're fired. They might have interruptions in education. They might even see problems with custody over their children. Or problems with housing. I mean, pretrial detention is very disruptive to people's lives, and the longer we keep people in who don't need to be there, the more we're going to see not just bad effects on appearance in court, but also bad effects on public safety, because people are likely to recidivate after they're released. So there's reason upon reason not to think that secured bail is going to do anything to secure public safety.
Excellent. Okay, I'd like to talk a little bit, because we talked a little bit about the risk assessment in and of itself, and I'd like to kick to David. David, if you could explain, praise Texas specifically, and if you can also delineate between the pretrial assessments and maybe the post-adjudicatory assessments that we see in the state with the TRAS, the ORAS, the LSIR. I'm from academia, this is what we do. The difference between those and the post-adjudicatory risk assessments. Yes. And the validation process as well, please.
Thanks for asking. That's a really important thing. So when we talk about the pretrial risk assessment we're using, or any time we talk about pretrial risk assessment, it is a risk assessment that is focused on trying to determine, as I said earlier, 2 things. 1, failure to appear, and 2, risk of future criminal conduct or risk of public safety. That's what it's looking at. The other risk assessments Derek just looked at, they measure different things. It's after conviction. It's looking at what is the potential for recidivism, yes, but then other types of factors which may be involved in needs for, say, probation monitoring or other types of classification. So they're looking at totally separate things. So when we talk about TRAS, ORAS, whatever the others are, ORAS actually has a pretrial version as well, but it's looking at different things. So at the end of the day, it's trying to predict those things. And the way that this is done, and this is really important, I'm glad Trisha mentioned this, validation is absolutely absolutely key. And one of the things that we believe is that any risk assessment that's being used must be validated. We agree 100% with that. One of the things we started working with A&M, and we've done some pre-validation of the tool we're using, but before any law were to go into effect, we will have to validate Praise Texas in local communities. That will have to happen and it will have not just a one-time validation. This is an issue in some jurisdictions. They validate and say, check, that box is done, we're done. Part of the validation process is continuing to look at the data to make sure, revalidate over and over again. So our tool will have to be revalidated consistently for us to be able to tell judges, you can trust the information that's coming out of this pretrial risk assessment, because if we're not validating it, things can change. So that's one thing. And so when we talk about validation, there's a couple of things I think are really important here. One, what the purpose of validation is looking at the factors that you're considering. So on the sheet that you have before you, you see a list of factors. We're looking at those factors. So for instance, what is the age of the defendant? If they're under 21, under 22, we're saying that's an increased risk of future criminal conduct. Well, is that just because we believe that or because the data shows it? That's the question. Do they have a pending offense at the time of the current arrest? Is that a risk factor or not? And so you take all these factors, and maybe it's there's some risk assessments which say, did the person grow up in a 2-person home? And I will tell you, there's some people who have some concerns about this one. That is not included in our risk assessment. I want to be very clear about that. We've had lots of questions about some things like this. So what you do is you look at data and say, okay, we know what has happened in all of these cases, whether the defendant showed up or didn't show up, whether the defendant committed a new offense or didn't commit a new offense, whether they committed new violent conduct or not, and look at all the various factors, study millions of cases, and say, does this risk assessment predict as we would expect it to predict with regard to their risk scores? If the risk score is high and says they're not going to show up, did that accurately predict in a significant number of cases what actually happened? That's what validation is. The other thing that's vitally important, and we believe this is something that the risk assessment we've put together has currently stood up to that, and we will once again validate and test against it as well, is it overclassifying or underclassifying by certain demographic breakdowns? So race, gender, location in the state, all those things have to be tested as well. I will give you a specific from the public safety assessment that we are using. It has been validated in various jurisdictions all over the country multiple times using millions of records, always been proven to be predictive in its from a validation perspective. They've also tested overclassification, underclassification, including in Travis County. It was done in Travis County. So when I say overclassification, overclassification, so for instance, does the risk assessment say that African Americans are more likely to not appear at court when in fact they appear more often than what the risk assessment would say? Does it say that females are more likely to commit new violent offenses when in fact it's the other way? That would be overclassifying, the tool overclassifying. The opposite may be true, where it says Caucasian females will not commit new offenses when in fact the data shows they are. So you look at the data and you say, is this classifying correctly and is it predicting? And what I can tell you about, and every risk assessment must go through that in order to be something that judges can rely upon to make decisions, and the information needs to be reliable for that. What I can tell you with the public safety assessment is validation, it's been proven to be a validated risk assessment. The second thing is, it's been tested in multiple jurisdictions across the country. It has never shown to be an overclassifier. It does not show to actually overclassify by any demographic. There's one exception to the classification. It has been shown in one jurisdiction to underclassify the failure to appear rate for African Americans. And of course, we need to test that. But if that's the worst case scenario, that's underclassifying on one factor with failure to appear, I think we can rest assured with something we'll have to look at with ours and continue to do that over time.
And I want to underline 2 points that you made. One, that we're talking about the actual information that we're shoveling into this thing. We're talking about individualized criminal history. This is not there's no sort of aggregate variables here.
That's correct.
And obviously, as you've seen when it came into entering that information, there was no field for race. The closest thing we had to demographic information was age.
That's correct.
Which, also coming from the criminological perspective, is highly, highly predictive of probably more of future offense than necessarily failing to appear. But that's a very good point. And secondly, I think in every place that is adopted, especially we delineated between the post-adjudicatory risk assessments, the one where we're talking 150, 200, sometimes even 250 variables that just cover the broad panoply of someone's social existence. Those are for different things, and they can be used irresponsibly. That's for sure. Obviously, they should not be making decisions about, guilt or anything like that. But we do see folks who use non-pretrial instruments in a pretrial context. But this is pretrial context is more of an Excel spreadsheet, as you guys have seen. And so it's all. When I talk about this, I call it it's all basically cards up poker. Because it actually shows what is going into it, and then if asked, you could actually show what's the mathematics behind it. It's not this black box algorithm that spits out a number. And the good thing to also highlight about kind of the approach that folks are taking here in Texas, folks that are taking in Ohio and some of the other states that have done this, is that they're also not binding the decision of the judge. You cannot. While you can't capture someone's entire social existence in across 3 domains and 9 overall questions, there's some things that you actually need to have eyes on for. But to Trisha's point, that means that could be one of these inflection points for some of the pernicious bias that she feels could be injected at this point. And so that's something that's very important, something to be very cognizant of. So in our run of show, we are at the point where we actually go into question and answers. And so while I could probably moderate discussion for another hour or so, you just had that Chick-fil-A, so you might be dozing off. So anyway, would like to open up question and answers for the audience. Just quick housekeeping on this. I really prefer that questions be kept to under 5 minutes and hopefully end with a question mark and upward inflection. In other words, not a statement, but rather a question. Prefaces are fine if limited, just so we can get as many in here as possible. So Clint will be taking around the microphone, and if you'd like to ask a question, just raise your hand. Ma'am.
Hi, I'm Elizabeth Earl. I'm a judge here in Travis County. Thank you for having this forum, and I'm sorry I'm late. I was at court, actually.
Well, thank you for coming.
So it's a question I have. I think in Travis, I see Stacy here, and I know that in Travis County we do a lot of personal bonds, and that's what I think the judges prefer, because a personal bond is their promise to come back to court. They don't have to post a bond, and they show up. What we're finding is when someone does fail to show up in court, and there's a bond, so then that way that means that they are no longer on the personal bond anymore. Has there been any studies on, because I feel like if I have a face-to-face conversation with someone and say, okay, I'm signing this bond and your personal bond, and you got to show back up to court and you got to be here, and it's a accountability for them, and they have to come back to see me. Have you seen that in jurisdictions where there's a face-to-face with the judge when they're signing that bond, that they're more likely to appear?
I don't know that I've seen a study that, I think Trisha mentioned this maybe before you got here. I think what we've found, and the studies do back this up, that the number one thing of getting defendants to show back up to court on a personal bond or any type of release, any release, even on a surety bond, is a court notification. A notification of, hey, your court date's next week. How many of us would miss our dentist appointment if we didn't get a reminder or text to us? It's the same thing of people not showing up. And so one of the things that I do believe is important is for us to figure out a way to have court notifications of reminders, come back to court. But I'll look for that, Judge, and see what we can find.
And on that thing you mentioned there, Travis County, we just started a pilot program for text notifications. And my court is the only court that's doing it so far. We're seeing how that's going to work. I'll get you those numbers because we just started it in the past, month or two. Yeah.
Everywhere that I know, Kentucky, who uses a significant amount of pretrial risk assessment and personal bonds, they said that is the number one. And in fact, one of the things that we'll have an issue that we'll have to be educating judges about is, a lot of times there's a tendency, once again, for judges to also want to over-condition, so place a whole lot of conditions on someone. And what actually Kentucky is saying is you can actually do harm there as well by putting more conditions that were necessary, and that the number one condition necessary for a defendant to show up to court is just a straight-up text reminder.
My junior high principal always said I was setting myself up for failure, and that's generally what we saw when we look at how many conditions, especially if not applied to the individual offense or proclivities. Do we have any other questions, ma'am?
Thank you. I'm Leslie Fitzpatrick, and I'm a criminal defense lawyer from Williamson County. And one thing I was looking at, because right now with mental health and drug abuse and everything being so prevalent, how do you address, I mean, certainly when they hit the jail, if you've got a person that is clearly mentally ill, off their medication, or someone that is intoxicated or under the influence of drugs, how does that play into your assessment, this Praise Texas?
So the risk assessment, as you saw, does not rely upon any interview with the defendant. So it's just based upon factors which are readily available, either in their criminal history record. Our intent, we've been very clear about this with the legislature with funding requests. Our intent is to integrate this with the existing criminal history databases. So all that stuff I entered, you probably noticed most of that stuff is available in databases, so we could enter that information or pull that information in straight from DPS's criminal history information. And then bring in failures to appear. But with regard to mental health history, that's not a part of the risk assessment right now. Any sort of, if they're intoxicated or on drugs, that's not a part of it. That would be something that would have to come before the judge another way. You may know already in law there's a requirement that if a defendant is shown to have a potential mental health issue, that judges are required to order an assessment already for that. So that would be another piece of information that the magistrate could consider as part of their determination.
I think that question really highlights why it's so critical, both from a constitutional perspective and a public policy perspective, that we get a counseled adversarial hearing as quickly as possible. This piece of paper that's going to judges is going to improve the information that's available to them, but it's just not a substitute for an interaction with the defendant, and a meaningful one. And so in cases which are very common, where we have people who aren't literally incapable of advocating for themselves, or cases, even in a general case, if there's not a mental health issue or the person is sober, we're really putting defendants in a catch-22. When they're standing in magistration, it's their one chance to get out, and their choice is to either exercise their right to remain silent, which they've just been admonished of, or try to advocate for their own release. In all likelihood, not knowing what the factors are that bear on release, or whether or not they're going to say something that makes it likelier that they'll get out or actually harms their criminal case. So while risk assessments can help, they're just not going to give judges enough information to make meaningful decisions about whether someone, under what conditions someone should be released. If we want someone in the situations that you're describing to be successful when they're released from jail, they might be assessed as a medium or high risk. What we're labeling as medium or high risk is a policy choice. And what that tool is telling the judges is not, this person is likely going to fail if you let them go. It's, this person is likely going to fail if you let them go on no conditions. And so what that red or yellow flag means is that it's someone that a judge needs to be looking at and thinking carefully, this is the person who I need to ask a lot of questions and figure out what conditions of release can I tailor to their needs to make sure that when I let them go, they're going to be successful. They're going to come back to court. And those people with those unique needs are people who need that interaction with the judge the most, and they need it quickly because jail is particularly harmful to people who have mental health issues. So for all these reasons, I think that the risk assessment is great, but it's not enough, and we need counsel and we need meaningful hearings within 24 hours to make sure we're getting people out who shouldn't be detained in the first place.
I just want to piggyback real quick. So the judge does order an Article 1622 assessment if they believe there is probable cause for a mental health issue. However, what I've also seen is that they will set a bond, and a person bonds out of the jail before the assessment is done.
That's correct.
So doesn't that put that person in society at more risk if you're letting a clearly untreated mentally ill person out of the jail before they've had the assessment?
Well, I mean, I don't think we want to be making a decision to hold people in jail just because they have a mental health issue. Judges can order as conditions that they seek mental health treatment. The other thing I think, and I know this panel is not about mental health, but what we also know is just because someone has a mental health condition does not mean that they are going to be riskier to the public. There's a lot of studies showing that's sort of our feeling, I think, as society, but I don't think that's backed up by the data. But judges, I mean, it's important for judges to know that information because they can set conditions, require them to go get an assessment, even if they get out. 1622 allows them to go get that assessment even if they get out, and also to seek treatment.
Sir.
My name is Justin Berry, and I'm a police officer here in the Travis County area as well. So from a lot of my colleagues, I can tell you how grateful they are that this conversation is taking place. Do you, as part of this assessment, do you believe that integrity-related crimes such as failure to identify should be a indicator of their integrity in the sense of the likelihood to show back up or to reoffend or things like that? Do you believe that should be a key component to the risk assessment?
Well, I think my answer to that would be it's all about what the data shows. When we do the validation, we look at those questions, which is that a predictor of failure to appear? I think, at least from the risk assessment that we're using right now, that was not shown to be a predictive factor. And so we've, sort of taken out the thought about what may or may not and looked at what the data shows. And that'll be part of the continuing validation is, if there is a consistent pattern of people who have failure to ID, for instance, who then don't show up to court, then maybe that becomes an increased risk factor. But as of right now, that would have to be shown by the data to be a risk factor which contributed to that failure to appear before it would be a part of it.
I also think I want to take that opportunity to clarify a comment that was made earlier about the idea that the presumption of innocence is lost when you're making a bail determination. That's not true. The presumption of innocence is retained. Of course, judges can consider information in a probable cause affidavit and decide whether to agree with it or not agree with it. That information shouldn't be taken as true in all cases. And judges should assess it the way that they would assess an officer's testimony or affidavit in any other case. Again, the fact that there's a probable cause affidavit there, evidence from the state, and then a risk assessment, and there's essentially no evidence on the other side for the defendant or in the defendant's favor is another reason why it's really important to get counsel into that hearing.
Right. And I would also highlight that the introduction of any sort of exculpatory evidence could actually be on behalf of the risk assessment, which is why folks on the right definitely support that in limited circumstances as well. Chance.
So I just had a question. It seems like Miss Trigilio.
Trigilio.
Yes, I'm sorry. I'm from Texas. Names like that are hard.
Everyone struggles.
I was able to pronounce it correctly.
Yes. You're from Ohio. But
touche.
But so it seems to me that you spoke a little bit earlier about how ACLU is concerned with like racial equity within the justice system. It seems like you guys would be really excited about this tool because it would allow you to have data that shows across the board sort of an objective baseline where you could compare on the basis of race or class, et cetera, whether or not that actually the amount they're being released for matches up with the risk assessment. So it seems like it would provide an objective criteria by which you could measure, whether or not there were in fact equities or inequities in the system. So I just want to know if you wanted to speak on that at all.
So I think that's a really interesting point. The risk assessment is an opportunity both to be thinking critically and in a race-conscious way about the information that's coming into the tool and also the results that are coming out. So it was mentioned before, it's certainly true that we're not inputting a defendant's race or their income into this tool, but we need to be very conscious, and I'm glad that we've been conscious of this with the OCA's tool, that we're not putting in factors that are actually a proxy for income or a proxy for race. And so the reason that I'm starting to hesitate as I'm speaking is the point that I'm ultimately making is people of color are going to be disproportionately likely to have had a misdemeanor conviction in the past. And that's not because they're riskier or more likely to commit a new crime. It's because of racism in our criminal justice system. And so I think that that's something that we want to be conscious of, and that's a reason why testing these tools for racial bias before they're implemented is so important, because we want to make sure that the tools aren't inadvertently amplifying an existing inequity. And then on the back end, we want to make sure that as the tool is implemented, it's being used in the way that we want it to be used for, which is we want to see rates of pretrial release go up without a negative effect on public safety or appearance rates. And we also want to make sure that those release rates, as they rise, aren't just rising for white people, which is actually something that was seen in New Jersey when these reforms were undertaken. So we want to make sure on both the front end and the back end that this is a very race-conscious process.
I want to add to that. I think, one of the things that we're excited about with the risk assessment, and we've spent a lot of time talking with the Arnold Foundation and others in this area with this particular risk assessment we're looking at, is because, one of the reasons why I mentioned and stressed earlier the whole idea of looking at overclassification, underclassification is because if you think about it right now, judges with no information, maybe just, we all know that implicit bias exists. We all have it. And so there may be some bias even built into the system that maybe even be being increased by bail setting. One of the things that we know the risk assessment by testing the overclass and underclassification, it's looking at real data. What happens with Caucasian males in this instance? It predicts this way. Is that what happens? It's not based upon what we think is going to happen or what has happened in the past. It's what actually happens, and are those predicting accurately? And so in a sense, I think you could make the argument that perhaps it's actually reducing some of the bias that's in the system. It's something we have to monitor. One of the things that I know we've been asked directly by the legislature about this situation is, what are you going to do with the data? Well, we're going to keep the data. We're going to be testing the data, not individualized, having information on everybody, but having data that we can actually be able to test what was predicted in this instance, what information went into it, what happened with it. So we can answer those questions that Trisha lays out about is the impact having what we think it's having.
Right, and that's a great jumping off point for that point I was making earlier about this is the advantage of at least, if not magistrating everybody, putting everybody through the risk assessment system. Because again, everybody that touches the criminal justice system is part of the criminal justice system. One way to really skew it to over-prediction would be if we basically drain the low-risk pool. And that's something that we've seen actuarially in the construction of these risk assessment instruments. Sir.
Well, I would just want to respond to that point by saying, what we label as low, medium, and high is just a policy judgment that we're all making together. And so if we are seeing great success and we're seeing people who are low risk cycle out of that pool, that would just be a matter of adjusting what it means to be low, medium, or high risk. And that's why revisiting the numbers that are coming out and making sure we're monitoring what our results are is so important. But I don't think that would necessarily be a bad
But they're
bad
policy
thing.
decisions made on actual observable outcomes. So what I would see though is that the bracket that we would consider low risk tightening if we drain out the low risk individuals. That's actuarially how that would work, because what they would be doing is contributing to actual validation of the tool as part of it. They would be that low risk sample. And if we remove that low risk sample, we're going to see the people that might have caught that cut point, they're going to be up into the next bracket simply because that bracket has what we would consider more dangerous people. So I agree that it's a policy decision, but it's a policy decision that's made on observable phenomena.
Well, my name is Harold Waldman, and I was listening, and there's some points. Trish, if I may, because I couldn't get your last name if I tried, I said that the information from the risk assessment was not available to defense attorneys, so they wouldn't have the information the judge had. Is the way that could happen. And the second thing is with the text message. Notification that you need to appear or you need an appointment is something that happens to veterans. We get text message all the time, but we also get an access number to call to say why we can't make it, so there's not a bench warrant. So if those two things can happen, if the information, the risk assessment can be made available to the defense attorney so they can have a response to the judge when they meet, and if there can be a text message and a response system so we can reduce the number.
So a couple of things, I think. One is, I don't think anyone in the judiciary has any concern with the public, with defense attorneys having access to the risk assessment. No concerns there. Trisha points out a really good point, which is in very few counties is there counsel that is present at magistration. That is I know I see some folks here from the Texas Indigent Defense Commission. I know they're working with counties and providing grants to establish that, but that's really rare. Most counties do not have, it's generally the defendant and the judge. Sometimes the prosecutor's there, but if you watch the Harris County videos that were posted on YouTube as part of the lawsuit, it's the prosecutor, the judge, and the defendant. That's it. There's not a defense attorney. But to the extent there's a defense attorney present, I don't think any of us have any concern about them having it and using it to advocate.
And I want to take 1 and 2. So part 1 of your question wasn't just the result of the risk assessment, but also kind of the algorithm and the way that works. And for each of these concerns that I raised on that slide, I'm not just talking about the tool that OCA is going to be recommending, which addresses a lot of these concerns. I'm also talking about the tools that other counties might adopt if they choose not to use OCA's tool under the proposed legislation. And that's why we would want to see, if there's a mandate for risk assessments, that mandate be particular about what an assessment tool needs to look like and what information needs to be public. Because judges across the state are going to be required to look at these numbers to make release decisions. To the second point, there was something I wanted to say. Can you remind me? Oh, the text message. So the text message system isn't just, hey, be here. The text message system is can be a little bit more sophisticated than that. It tells people about the logistics of getting to court. In jurisdictions that are a little bit more ambitious, it also tells people about ways to get to court, and there are offers of sort of transportation options in places that don't have public transportation, and then options to reschedule, like you said. And the people who run these companies report that the number one response they get back is something like, thanks, or I appreciate it. So it sort of takes down this myth of, everyone's trying to flee the jurisdiction, and more like, everyone has busy lives, and if we just work with people, we can lower those failure to appear rates pretty significantly.
All right, we have time for one more question, ma'am.
Oh, sorry, thank you. So, I'm like I said, I'm a criminal defense lawyer. I think it's great if we had an opportunity to be at the magistration, but there's two things that I'm aware of under our code. The person has to be magistrated within 24 hours of the time they come into the jail. And in my county, at the point of magistration is when the counsel is appointed. So unless you had like teleconferencing or Skype or something, 24 hours is a very short window to be able to have an attorney be at that magistration / initial bond setting.
So let me answer that. So just to be clear, the law is within 48 hours on a felony and 24 hours on a misdemeanor, but most everyone's magistrated in most jurisdictions within that first 24 hours. That's true. The way that jurisdictions that are having counsel present at the magistration are doing that is, one, they have a public defender's office, so that makes it pretty easy. They're on call all the time. Or two, there are jurisdictions where they are appointing counsel for the limited purpose of magistration. So there's basically kind of an on-call attorney who's there to do that. I think there's a bill pending that makes it clear that counsel does not attach to that defendant for the whole case, so that they can just represent them for that discrete task of magistration. And because there's some issues with the question about whether or not that attachment of counsel continues. If the defendant says, no, I like that attorney, I want to keep them, now that attorney has all those cases, which could be problematic. So, but that's an issue that's there. Can I add just one more thing before we leave? And one of the things that we've been talking about, as Trisha pointed out, there's a lot of lawsuits going on in the state in federal court. One of the things that we were really proud of out of the Fifth Circuit's opinion was footnote 5. You may not know it as quickly as I do, but I know about footnote 5. Footnote 5 of the Fifth Circuit's opinion says, Texas has been looking at reforming the system, and it says the last legislature had a bill pending that should that bill have passed, we might not be having this conversation. And it also says, and if something like that passes, we will need to revisit this issue. And so I think that one of the things that we're really thinking about, and I know it's been a talking point of the Chief Justice, is, shouldn't Texas try, as Trisha said, she doesn't want to sue all 254 counties, shouldn't Texas try to figure out a way to resolve this issue itself without the need for the federal courts to tell us exactly how to do it, in which case we may not exactly like the way that comes about. Maybe we can get to the same end that the federal courts are trying to push us towards in a way that's designed by Texas. And I think from the judiciary's perspective, we would really like to see Texas design its own system and its own solution to this. And I think that the legislature is looking at some proposals to do that, and we're happy to work with them and hopeful that some of that will come to a good end.
All right, everybody. Well, thank you so much for joining us today. Can I get a round of applause for our panelists? And we look forward to seeing you all soon.
See the tool in action. I was very interested